Okay, so good afternoon, everyone, and welcome to part 2 of topic 3. And this is going to be a continuation of our discussion of succession, and then we are going to look at enduring powers of attorney. So just what we're going to do today, just have a quick revision of what we did in session 1. More or less, it's just one slide. And then we are going to look at 2 topics. We're going to look at estate administration and an overview of enduring powers of attorney. As you will be aware, these are very big topics. So this will go pretty fast, and there will be some sort of gaps or things that may feel glossed over. If there's anything though that you're really struggling to get your head around, or you really are interested to know, then please ask either via your microphone or via chat, or later on in the questions to me part of stream, and I will do my best to answer those. So that's just for your records. Those are the outcomes we're looking at today. So we're looking more at the last 5 or so, looking at the kinds of gifts that can be provided very briefly, treatment of prior advances. I did remove reference to the treatment of prior advances from the study guide, but somehow it ended back up in the topic notes. Don't get too worried about that, but it is possibly helpful to know. And discussion on succession and the effects of different pieces of law on testamentary freedom, and then we'll look at enduring powers of attorney again. So just coming back to the first slide, or that slide that we looked at the first session. Essentially, in the first session, we had a discussion about what succession law is, the general sort of principles and legislation that look at succession law. And then we focused on what is required to make a will, looking at the circumstances such as what are the formalities of a will, what does it mean to have testamentary capacity, etc. And you'll recall that the existence of a valid will determine how an estate will be administered. If there is no valid will, or there's a valid will without an executor, then we are looking at letters of administration. And letters of administration and probate are 2 kinds of grants that are given by the High Court to basically signify the power of personal representatives to call in the assets of the estate and administer the estate. How that all works will depend very much upon what kind of property has been left behind, and the size of the property, where it is, if there is enough property to meet all the debts of the deceased, and also all the obligations or promises that have been made under the will. And then the people, because this is all about people in the end, who may expect to receive something under the will or from the estate, and that will very much depend on natures of family relationships between the parties, and also promises, and also just general cultural sort of understandings of whether or not someone should be entitled to receive under a will. And also, just as a note, economic factors. What I didn't mention, which is kind of relevant, and I did once go to a presentation or a discussion on the role of charitable foundations. And we don't look at charitable foundations in this, but essentially one option, particularly for wealthy people or people who have a significant estate once maybe their home is sold, is to leave a part of their property to charity. And community foundations are one sort of way of doing that. But what they talked about was that as this sort of baby boomer generation dies, then that is to some extent going to be the biggest transfer of wealth from one generation to another that we've experienced for some time. And that concept of inherited wealth, and also when we're looking at the current housing market, how many people are sort of waiting or expecting an inheritance in order to either get into the housing market or take the next step on the housing market. And that concept of the have and the have nots, the people who can leave that money, and the situation that people are living longer. So people are now having to wait longer to get into that property market. So there's a lot of things that sort of link in to this concept of estates and succession and who is entitled to what. So you can make all the wills you want. And in New Zealand, the starting point is that you should, as the testator or the will maker, have testamentary freedom, but there are still some limits. The first is that you can't give away property to others which is owned by jointly owned. So that could be a jointly owned bank account, jointly owned chattels, etc. That the survivor will take those in their entirety, and we'll look at a bit more at that in the next topic on property. But essentially, husband and wife own a house together in joint names. Husband dies, then the house will be transmitted by survivorship into the name of the wife, and she will sort of take all the interest in that. We'll be looking at the Property Relationships Act in more detail in topic 6, but the surviving spouse or de facto partner may choose to take a share of the estate under the will or intestacy, or half of the relationship property. And what's important to note is what forms the deceased estate may differ from what is in the relationship property share. And you take into consideration things like jointly owned property does form part of relationship property. So I have been involved in those decisions, when you're talking to surviving spouse, and essentially what you're doing is kind of listing all the property that they have interests in and then categorizing it, and then working out what the will gives them or intestacy gives them versus the division of property under the Property Relationships Act. And then we have, and this could go under just General Wills Act, or here, as if both parties have made what they're called mutual wills, which are defined in Section 30 of the Wills Act, but basically A and B both decide that they're going to make wills, and that they will essentially have mirror provisions where they each will benefit the other, or also the children of the other, particularly if there are children of previous relationships. And then one doesn't keep their promise in that will because you do have testamentary freedom, then there are grounds for a claim by the estate of the other or the other person to challenge that. So yeah. For children, and this is quite an interesting one, particularly when you distinguish between minor children and adult children, and then adult children who may be quite successful, particularly financially, versus adult children who may, for various reasons, require additional support, may have disability or other challenges. And this is where the Family Protection Act comes in. And essentially the starting point is the testator's, the will maker's moral duty to adequately provide for their spouse and children, and in some circumstances, grandchildren. But that will usually be where a grandchild has a very special relationship with the grandparent. There are two kinds of obligations that are recognised by the courts. One is just the straight obligation to provide support. And so that is clearly, for example, if you are leaving behind a child who has significant physical disabilities, and you may have some additional sort of duties or seen to support and provide for them in your will, versus the obligation to recognise the relationship. And this is what often comes up when very wealthy families and the children are fighting for their shares of $1 million pies, and some children, will be quite wealthy themselves, but they see this concept of fairness, they see this concept of recognition. The courts have been very clear that not every child needs to be treated the same, and they start from the position that they will only depart from the testator's wishes, the will maker's wishes, or how the rules of intestacy apply, only as much as is required to meet the obligation that has been breached by the deceased. The courts will often say that this is not calculated on a percentage basis, but in reality, when you are a lawyer and you are advising clients, previous case law will usually give you an idea of what the claim could or should be. And you're usually talking anything between 5 to 20% of an estate each. For each child, a little bit more for spouses, but it'd be rare for a spouse to make a claim because of the property relationships legislation. And this is a developing area, but it's part of why, for example, we'll have a look at the later slide, the Law Commission is suggesting some changes. And it says, well, maybe we don't need too much legislation to meet all the obligations to children. Maybe we can narrow it down. Maybe there's some obligations and just the common law and what we sort of consider equity. And you may have sort of know about fiduciary obligations, for example, the obligations that lawyers have to act in the best interests of their clients. There's a developing concept of fiduciary obligations to children. And you'll see the reference to this case, A and versus D and E Limited, as trustees of the Z Trust, all anonymised. And the reason it was anonymised was because we have some adult children who, when they were young, were very significantly abused by the deceased in their childhood. So it had a significant impact on them. But the deceased was such a sort of terrible person that he, despite the way he had treated them, he still didn't want his children to receive anything from his estate. And so before he died, he effectively emptied out his estate and gave it all to his trust. And the children were not named as beneficiaries of that trust. And in those limited circumstances, the High Court saw that as a sort of breach of his fiduciary duty to the children, and there was ability to claw back some of that money. And once that's clawed back, it then goes back into the estate, and then from the estate it can be given to the children. It's quite new and developing, but it's quite an interesting concept, and it doesn't apply just to all children. But it is also a good reason why, for example, people who just say, well, I'll give everything to my trust so I don't have to leave anything to my children. There are some fish hooks there. There's also limits on testamentary freedom, including testamentary promises. So if they say X provides a service to Y on the express or implied understanding that Y will recompense X in his will. So you're not doing this out of the goodness of your heart. You're doing this because you believe you will receive benefit. And this could be from someone who is or is not related to the deceased. So it's not uncommon. You might have situations where you've got the bachelor who lived on a farm all his life, and the neighbouring sort of family helped him out all the time, and he did explicitly say, in exchange for helping me out, I will recognise you in my will. And in some circumstances that can occur. You also then have, the Succession Homicide Act, which was referred to in the last session, where, if you kill someone, then you should not be able to benefit from any rights of inheritance under will or intestacy, etc., that you might otherwise have. That, however, what's interesting, just as a note, is they make really, really clear in the new legislation on euthanasia and the right to die, that this, of course, you know, as you would expect, but it is explicit. If you help someone to die, use it under the provisions of the euthanasia legislation, and you follow that, then the Succession Homicide Act does not apply. So just as a note, and there is linked to the readings, a sort of, I think it's a link to, or a suggestion you read the executive summary of the recommendations of the Law Commission, because they only came out last year, and they have significantly reviewed succession law, and they reviewed succession law after they had reviewed also relationship property law. And as noted there, they have suggested that we have a whole new inheritance claims against estate law, which should be the principal source of law. And so that means that the parts of the Property Relationships Act that apply upon death, the Family Protection Act and the Testamentary Promises Act would be repealed, and new replacement provisions that are considered to be better suited to our current sort of contemporary standards should be made. And also just to update what is currently sort of the law relating to how estates are administered, which is currently sort of as noted there in the Administration Act, which we'll talk about a little coming up, Wills Act, Simultaneous Death Act, which, you know, as the name implies, addresses what is to happen if two people die at the same time. For example, in a tragic car accident, if you have the husband and wife die, and the Succession Homicide Act. Does anyone have any questions about these? Because I know things like the Family Protection Act can get quite controversial. Nope. Okay. So I know hopefully you can, depending on the size of your screen, you may or may not be able to read this. Just noting, I should have added some extra lines in here, but essentially, so you start with, is there a valid will? So we're jumping past the part where the executor and the personal representative address their obligations to bury the deceased. And I think I noted in the first session, there's no property in the body, and we'll talk about that a little bit. I think it's in the notes for topic 4. So the guidance on, you know, what is to happen with someone's body is not binding in the same way as the other terms of the will, although you would expect that the executor or the administrator sort of, you know, acts in good faith and in accordance as best they can with the wishes of the deceased. But you can think of even basic examples. If trust, you know, a deceased asked to be buried in a particular cemetery, but if there are no places left in that particular cemetery, or they, in one case we had a situation where the deceased, where a will maker had said, I want to be buried next to my wife in a particular cemetery, and they'd made wills at the same time, but the wife then died and she was buried in another cemetery. So of course, you need to sort of work out what's the best thing to do there. But starting with, is there a valid will? If there is, you get probate, and that is essentially a lot of documentation. It can take anything from, I think, you can draft up a grant of probate, a lawyer can in probably a day if it's nice and easy, submit it to the courts. They can grant it quite urgently, but it's usually best to wait 6 weeks. Expect 6 weeks. And then from the grant of probate or letters of administration, which you need some more documentation. For example, for letters of administration, you need to satisfy the court that you have checked with births, deaths and marriages that the person didn't leave any children that aren't otherwise accounted for. So those kinds of things. The administrator and executor then has to collect in the property, and that includes one bank account should be closed automatically upon death, but you can't do anything with them between death and getting the grant of probate or letters of administration. And then you can close them up, and often, depending on interest rates, etc., you may keep them in the bank rather than close them and transfer them through to a lawyer's trust account. Property like shares will need to be transferred into the name of the estate, but if they're just being sold, can be relatively straightforward, although chasing down things like link and computer share and finding out what or the share interests that are owned isn't always as straightforward as you would like. And also things like real estate needs to be transferred or transmitted into the names of the executors so that they can then deal with it, and if it's going to be sold, start making arrangements for that sale. They then need to pay debts, and that includes funerals and costs which have the first priority, and also taxes. So you are supposed to apply one, you have to sort out and make sure that a person doesn't have any outstanding tax at the time of their death. And then the estate is a whole new tax entity. And strictly speaking, you should apply for an IRD number, and you have to have an IRD number if you are going to be selling the property to a third party. Just as a note, it is a good practice to advertise for claimants. That can be divided into two kinds of claimants. One is just general debts, like does this person have a farmer's card? You must tell me within X amount of days that whether or not that person does, or the executor is no longer liable. There's also the question of whether or not you have the obligation to tell people who could otherwise claim, for example, under the Family Protection Act. So it's not unknown for a person when they're making their will to leave clear directions that they don't want their children to know about their death, and that they are not leaving anything for their children. And the courts have come back, and there's some sort of nuance to these rules, but the general rule of thumb is that the executor therefore isn't under any obligation to chase down those claimants, if that's the rules. They're not to do anything that is to obstruct it. So if someone found out that someone had died, a family member had died and may have left provision for them in their will, or they wanted to know, they have if they are then approached, they have an obligation to provide information, but they don't have an obligation to go and chase down everyone who's not named in the will, who potentially might think they should be. Kind of controversial in some areas. And then, the executor is realizing the assets and in accordance, and then distributing them. So if there's like, I leave my Ford F-150 to Y, then you'll be looking at distributing those, particularly if you are confident that the estate has enough funds to meet their obligations otherwise, for example, in distributing the residue and paying debts. And then you dispose of the residuary estate. So the residuary estate is everything that's left, and that is to be divided according to the will or according to the Administration Act. In some cases, what happens is you start as an executor, and once you've done your main tasks as an executor, if you still have to hold on to property, you then become a trustee. And even the courts admit that this is quite a blurry line as to when an executor can become a trustee, and therefore technically subject to the rules of the Trust Act, etc. But at some point in time, for example, these are getting less common, but if you leave your a life interest in your property to your surviving partner or a child, and then so they can live in that property for a specific period of time in accordance with particular rules set out in the will and just some general sort of legal principles, then the estate or essentially continues, and the executor becomes a trustee for that purpose as long as the estate is not wound up. Any questions there? It is very whistle stop. I'm going to assume that this is all making sense. Great. One of the biggest difficulties, particularly with people living overseas, but also having potential executors and family members overseas and beneficiaries overseas, is the administration of wills. For example, you're looking first at where the property that the deceased left behind is, and under sort of property rules relating to essentially rules of private law and what's often called conflict of laws, which is basically private international law. When it comes to immovables such as land, then the law of the land applies to those immovables. But when you're applying to movables, which are often usually personal property, bank accounts, etc., it's the law of the deceased's domicile. But for example, if someone leaves a bank account in, as we've had, Jersey, which is a protectorate, which is a separate sort of entity within the sort of realm of the United Kingdom, you will have to get a grant of probate from the Jersey Royal Courts of Justice in order to, and an agent to do that in order to claim those assets, and then those assets then have to get transferred back to New Zealand in accordance with all those costs and foreign currency exchange issues as well. But they are not subject to the things like British inheritance law. However, if one of the beneficiaries of that estate in which some of the funds were in Jersey was British, then they could potentially have some tax liability, which is up to specialists in the United Kingdom to advise. But it could also come down to, for example, where executors are. So I once did a sort of CPD webinar on tax and administration in estates and overseas issues. And I started to panic a little bit because we had an estate where, for reasons I won't go into, the only two people who this person could have appointed executors were Australian. And so they were living in Australia. And it was pointed out that at some point in time, if the executors continue to live in Australia and this estate becomes a trust, then Australian tax rules that apply to trusts may be applied to that estate, because the legal owners of that estate, in terms of law versus equity, which I haven't talked about too much, would be Australian. So basically the rules are, it's complicated and you're often going to need to get specialist advice when someone has significant international property at the time that they are making the will, and then you're going to have multiple advisors based in each of the different jurisdictions to sort this all out. So I just see some in chat. Bye, Victoria. Okay. So just as a note further along, and the Wills Act, because it's a relatively modern piece of legislation, is actually quite easy to read and to follow, but it does talk about things like the disposition of land and property and real property in New Zealand. It talks about movable property along the lines of what we've talked about. So when New Zealand law will be seen to apply and to a movable property that's based in New Zealand, or when grants of probate may be required to deal with property that has been left in other countries, for example. What's important to note is often in wills, there will be something called a gift over clause, which isn't necessarily required. Now we've got section 23, but a gift over a clause, for example, if you say, I leave the residue of my estate to be divided equally between my 3 children, you know, Jill, Jack, and Mary, but in the event that one of my children shall die, then they're leaving living children who reach the age of 20 sometimes, then those children shall take the share of their parent. So if Mary was to die before the will maker, then Mary's 3 children would each share in that 3rd share. So essentially they would get a 1/9 share of the residue of the estate. And essentially issues relating, for example, disposition and fractional parts. So if it wasn't a case that you could, so if Mary died without leaving a child, then her 1/3, in accordance with section 28 of the Wills Act, would go back into that residue and then be split between Jack and Jill. So it wouldn't be lost to the parties. The other provisions, for example, the disposition may encompass a power of appointment. So for example, and we'll look at trusts, if your trustee says that a trustee may appoint a new trustee in their will upon their death, then in their will they can say, you know, upon my death I appoint blah, blah, blah as a trustee to my trust. There are still documents that need to be signed and set up for that, but that is a power that can be exercised. Any questions? Just keeping track of the time. Sorry, I should have got rid of this. Highlight. So hodgepodge is relevant, particularly in these situations these days. When I was mentioning earlier, you know, what happens when you've got parents, or particularly baby boomer generation, who are holding assets, often in the form of land, and maybe don't necessarily want to die before they assist their children into property. But if they want to, if they're leaving more than one child, want to leave, but treat those children fairly. And in that situation, you would be essentially treating that advance to the child to purchase a house as a loan that then can be called back. So it becomes an asset to this estate, and it goes in to that division of property, to the asset pool as sort of noted there, and then divided up. The reference to the first method and second method essentially comes down to whether or not there should be interest added to that amount that has been advanced, so that to make it fairer to those people who didn't get the benefits of the funds, versus, for example, the child who was able to use, you know, their $50,000 to purchase a house, which has then significantly increased in value. And as you all note, and this is from Howard, the preference of many writers in terms of fairness is the second one. However, in terms of practicality, and often, you know, if the family is getting along, they sometimes don't worry too much about those issues of interest, particularly since they can become quite a headache. One of the significant issues, though, is in this classification of advances, is that concern about gift or loan, because as you might be aware, if you're getting money from parents for a house, the bank will want to make very clear that that is a gift and not a loan. And yet, the parents may wish to call that into that advance to be taken into account at the time of their death, and that's not always nice and easy to sort of deal with, because you're kind of sort of telling the bank one thing and going about it in terms of your will in another way. That also becomes quite relevant when the parents of one spouse might loan or sort of advance money for the purchase of a property, and whether or not it's a gift or loan will be relevant to the pool of relationship property and what is owed, and that can be quite significant. There's a reported decision, I think it's Poplar Trust, Tanya Booth and Poplar Trust, where essentially Ms. Booth was arguing that a $1.2 million advance that was given to a family-related run company, which was subject to relationship property, should be considered a gift and not a loan, because if it was a loan, then she would have her share of the relationship property reduced by about $600,000. She did not succeed. But yeah, so it comes down very much to what was the intention of the will maker, what was the understanding of the beneficiary, and there needs to be the importance of documentation and clear communication. So if it is going to be an advance, and this is a family that has accountants and financial advisors, then those advances should be tracked and recorded on some kind of balance sheet. And the same thing in terms of these rules can be taken into account of, for example, if you're doing a final distribution from a trust. Oh, that was supposed to go. So sorry, this is what happens when you can see that I balanced things on previous slides, and I might go and delete that. So talking about sort of the web of different pieces of law that apply, when we've got the Administration Act 1969, and this includes a large sort of amount of sort of provisions which are not necessarily all that easy to read, but some of the powers include, for example, something I mentioned last week, which is this ability to, when you've got small estates, the ability to administer them and call in the assets without a grant of probate or letters of administration. And that current prescribed amount is $15,000 in any one institution. So that prescribed amount is set by legislation. Other relevant powers include things like the protection of administrators or executors against certain claims regarding the estate, or against the estate, such as under the Family Protection Act or Property Relationships Act, if they don't distribute before 6 months after the grant of probate. So this is one of the reasons why estates aren't sort of distributed really fast unless they're very simple estates, and often the administrator or executor will get an indemnity signed by the beneficiaries, which will basically say, in exchange for getting my share of the estate early, I acknowledge if there is a claim against the estate, I might have to put up and return my cash or pay that to the claimant. So yeah, the 6 months, however, if they kind of know, it's sort of a good faith thing. So if they know that a potential claim is in the offing, it's not a good thing to try and distribute just on that exact 6 month deadline. And if the assets are distributed, then the executor could be liable, but also those assets can be traced as well by the courts, and there's powers of the court to intervene in that. So all of the acts, the Family Protection Act, the Property Relationships Act, the Testamentary Promises Act, all specify deadlines for making a claim, and they all, to add complexity, slightly different in the way they are worded, but generally it's like the 6 month, 12-month period. Which is why if you know that there's potentially going to be a challenge to an estate, the distribution will not happen quickly, even if it's very simple to call in the assets, deal with the tax, etc. And the other part is the disposition of the property in the case of intestacy, and that's set out in section 77. That's listed in full in your notes, but if we go here and look at an example here, so these are the first two. So husband, wife, civil partner, civil union partner, surviving de facto partner, which is a note, means that they needed to effectively be living together at the time of the relationship. So the difference between, you can be a separated husband but not have a separation order, which are very rare these days, and still receive under intestacy. But if you are a separated de facto partner, and you've been apart for a few months, then you don't have an entitlement under this legislation. So sometimes it does come up, what is actually the significant difference between, being married and just being a de facto, and it comes into these little sort of niggling sort of bits of law where de facto partners can sometimes slide through the cracks. So if you just leave if you die and the only person you leave behind is your spouse, then they are going to get all your personal chattels and everything else. But if you leave two children, and that could be, and we've got an example here, two children from that relationship or a previous relationship, then the chattels will go to your spouse, but then the residue of your estate will be divided in accordance with what's stated there. So you first get the prescribed amount, or their spouse gets the prescribed amount of $155,000. And then anything that's left is divided into 3. And the children, if it was 2 children, would get 1/3 of that. So you take 155,000. So in the example here, you can see how and why FPA claims and Family Protection Act claims can arise. So if you have X and Y, and X has 2 children from a previous relationship, X and Y jointly own a home, and X has 100K in KiwiSaver. If X dies intestate, then Y is going to get that house by survivorship, and all of the KiwiSaver funds under intestacy, because it doesn't get up to that 155,000. And so the adult children will receive nothing. And that could also be the case even if they were minor children from a previous relationship, they would also receive nothing. And this is where there becomes, and it's very complicated, but essentially what a lawyer would be doing is first trying to trigger property relationships claim to claw back 50% of the estate, and then have that, which would see that division of the house, and then sort of create a larger pool. But it's a lot of paperwork, it's a lot of law that needs to be sorted out for that. Most of these claims are settled by something called a deed of family arrangement, which requires all the interested parties, so that's the executors and all beneficiaries who are affected, and the claimants, to effectively sign a deed, which is a witness document, a witness contract that needs to comply with certain formalities to agree to depart from the will or the rules of intestacy in a particular way. So that can be done. So it can even be the case that if X dies and everyone thinks that their will is stupid, and that all the parties can, if their formalities are followed, agree to depart from the will. So that's it for estates. Any questions arising from that? Comments? Okay. So enduring powers of attorney, if you watch like American television, etc., I think sometimes they're called living wills. And to some extent, I would say having an enduring power of attorney is more important than having a will, because when you're dead, and you don't really know what happens to your property. When you're alive, it's very much the case that you care about how your property is used in order for to take care of you and the people you love during that time. So I'll just have a look. Yes, sorry, the slide, so I'll just see here, the slides are on stream. They were a little late. I'm also going to replace the middle, that extra slide that shouldn't be there on testamentary capacity. So yeah, so enduring powers of attorney. Essentially the example, I was trying to think of an example for people who haven't sort of thought of them. And essentially, powers of attorney are like creating a sort of an avatar that goes out into the world, just like an avatar might go out into the digital world, but this goes out into the real world. And the avatar has whatever powers that you have granted them. And the difference in the kinds of powers of attorney, which we'll look at, is under a standard power of attorney, your avatar can only act, for example, like as long as you're in front of the computer, as long as you're able to direct their action. Even if you're just sort of sitting there watching what they do and not paying attention, you still need to be there. But the case becomes, well, what's going to happen when you are away from the computer, or you can no longer give those directions? What is to happen to your avatar then? And enduring powers of attorney were created under the Protection of Personal and Property Rights Act, which at the time when it was passed in 1993 was considered to be quite a state-of-the-art piece of legislation in comparison to international law. And although powers of attorney are the bit we're talking about here, one of the reasons it was created was that there was a lot of closure of things like care homes, for example, in down in sort of Levin, I think Lake Alice, all those sort of things were used to put people who had sort of mild to severe intellectual disability, etc., away from their families, and they were starting to put these people back into the community, and you needed ways to support them, etc. And so powers of attorney were created, enduring powers of attorney were created at the same time to address the situation of what happens when someone loses capacity during their lifetime. And so this is just a brief overview here. So standard power of attorney, and they powers from the document. You would be surprised how many different documents insert powers of attorney in there. Sometimes mortgages, credit contracts, all kinds of documents might say, you grant us a power of attorney to, for the purposes of signing X document or making whatever decisions are required. They get, from my experience when I was working in community law, and this is some time ago, powers of attorney was put into some very interesting places. But these days, quite common, for example, if you're just going overseas and you want someone to be able to sign some documents for you, or if your trustee so allows, and you're doing it in accordance with the Trust Act, you can also appoint a power of attorney while you're going overseas briefly to act or sign documents for the trust. And those, to some extent, are just purely creations of sort of the common law, although there is some legal recognition, and they end upon revocation by the donor, again, when the donor loses competence. Or the attorney can say, look, I don't want this power anymore, or the death of the donor or the attorney. There are two kinds of enduring powers of attorney. There's one for property, and we'll look at what the property is defined as next. And there's one for personal care and welfare. the difference, and you'll see that under when the attorney can act, the property attorney can take effect immediately upon being signed by everyone, if the donor so wants, and continue past, the lack of capacity. Or it can just be triggered when a health professional certifies you as incompetent. One reason it's quite good for that competent-incompetent situation is, for example, and this is often pre-technology, but if you broke your leg or were unable to leave the house, so you're not able to go about those duties to manage your property, but then your donor can do that for you. So your attorney can do that for you. And also when you are losing capacity, for example, things like dementia, there's not a clear sort of time when you are no longer able to manage things like your bank accounts and decisions. But banks, etc., have got into a lot of trouble for not properly reading a power of attorney and for giving property attorneys access to bank accounts when it hasn't yet been triggered. And then they have to pay the money back and get told off by the banking ombudsman. There are requirements as to who can be a power of attorney. For example, you need to be over 20 years of age, you need to be not a bankrupt. For property, it's quite wide. You can have individuals or trustee companies such as Public Trust or Guardian Trust, it's now Perpetual Guardian. And you can have more than one, which can be a good thing, particularly if you've got a number of family members who are interested in helping with the property. There can be too many. For example, I had one gentleman who, in order to make his kids, his sons, feel he was treating them fairly, named all three of his sons. On a practical basis, depending on how the attorney is set up, whether or not it's got joint or several powers, that's a pain in the bum. Not least of which, because that means 4 sets of individuals need to sign that document, which then needs to be circulated, in this case, to London and back. And does anyone know what joint or several powers mean? In this case, you can require that all attorneys must act together and sign the same documents, or you can allow it to be just one person can sign. That will also matter if you if one dies or not. If it's several, then the other 2 attorneys can continue. Strictly speaking, if it's phrased in a particular way as joint, then the attorney in some circumstances can come to an end. The difference with welfare attorneys is you can only appoint one individual. There is an obligation of both the property and welfare attorneys to talk to each other, and to some extent the property attorney is subservient to the welfare attorney. What that means is if the welfare attorney decides that it is in the best interest of someone to go into a care home and has access to certain funds to pay for that care home, and also maybe to pay for some other, sorry, I saw Paul sort of has answered the joint and several, so sorry about that, just a little fast. So yeah, if they have sort of getting into a care home, etc., then the enduring power of attorney for property has an obligation to act and manage the property in such a way that there will be adequate funds. And the power of attorney ends when the donor revokes it, and the donor can revoke it at any time while they have capacity. And that doesn't necessarily mean full capacity. That just means that they have enough capacity to know what they're doing and the implications of that decision. If the attorney decides that they wish to stop acting, and that can become quite difficult, for example, if there is no one else to step into the shoes. When the donor dies, now that might seem quite obvious, but the number of cases where, for example, you've got enduring power of attorney for property, and maybe it's a daughter, and then mum dies, and the daughter is not the executor of the estate, but the daughter wants to make sure that mum's wishes that all the siblings could come to the funeral happens, and so uses money from mum's bank account after she's dead to pay for the siblings' airfares. You know, from a moral sort of standpoint, it's not necessarily wrong. It's not something that you would think, oh, what a terrible thing to do, but it is unlawful. As soon as the donor dies, your powers under their power of attorney end, and those bank accounts should be frozen, and the power passes to the executor. And even if you are the power of attorney and then you are named as executor, there's still a hiatus between when that person dies and when you get the grant of probate and are allowed to administer the estate. The death of an attorney or incapacity of an attorney, but it's often recommended that successor attorneys are appointed. So if I can no longer act, then this person can step into the shoes, or the intervention by the courts. And I note there, and I've just suggested, that you do a bit of reading. Essentially, the reason you want to set up enduring powers of attorney, firstly, is because if you don't, and then someone needs to go into a rest home and is sitting on a hospital ward and can't be discharged until the rest home is available, then or will take them, then you'll need to go to the family court for orders. And if you're going to the family court for orders, it can take time. You need a lawyer appointed for the subject person, so for the person who's lost capacity, to figure out is the proposed person and the best person to be the attorney, etc., etc. And then even once the orders are granted, they are reviewed every usually 3 years, and the property attorneys, property managers need to file reports which are regularly examined by public trust. So it's a lot of work. So they're not permanent, you're subject to review, etc. Unlike if you've got an EPOA, if it's all valid and set up, then it is permanent. Nearly done. Any questions so far? Just shout out. So just as a note, for personal care and welfare, that includes health, well-being, enjoyment of life, including matters such as where the donor lives and medical treatment they need. But there are some really important exclusions, and one of the biggest ones is essentially you can't turn off life support. So you're not given that power of life and death. And if someone wants to do that, then they're going to have to make direct that, do not resuscitate, etc. Then they are going to have to talk to their doctor about making an advance directive. And there's some quite interesting law about how binding those are, because how does a doctor, for example, know whether or not the advance directive, you changed your mind since you made the advance directive 2 years ago, for example. Property includes anything the donor owns, leases, hires, or holds on hire purchase. So land, buildings, money, goods, shares, stock, all those kinds of things, very, very wide, but does not include interest and trust property, which is really important. So when someone loses capacity, their EPOA for property cannot step in, for example, to act as they would, as the incapacitated person would for the relevant trust. Other provisions need to be made for that. These are really long forms with really long explanations, and I think I provided a link to where you can find one version of the standard forms on the Office for Senior Citizens, and they're quite good. The other common format of the form is from the Auckland District Law Society, who have their own sort of version. It's quite small writing. Both of them are equally as valid. They still need to be completed in the same way. They still need to be witnessed by the appropriate people, particularly by the donor who needs to advise the donee. So it's not a nice, easy situation of you get instructions and you turn up and it gets signed. you have to sit down and spend like 15 to 20 minutes explaining what these EPOAs do. Often I've done it in hospital beds where the donors, are quite sort of drowsy, but you have to ask the right questions to figure out if they do actually understand it. But they can be tailored to add, preferences as to care and medication. For welfare, for property, you can say that I want some family members to continue to receive, annual gifts. You need to continue to give certain money to charity, etc. And something that I haven't mentioned there, that you can place obligations upon the attorney to regularly consult and or provide information to others, and that can often be other family members. So just as a note there, significant overlap in capacity in EPOAs with that of concept of testamentary capacity. So there's a presumption of capacity that's central. So you start with someone has capacity. You can't just use them because you disagree with a person's decisions, such as a refusal to accept assistance with day-to-day needs, an agreement whether or not they are refusing to go into care when you think that they should, whether or not in one case someone was an alcoholic, wasn't taking care of themselves, effectively lived like a hoarder, but they weren't found to be lacking capacity on a medical assessment. And in that case, it was a situation of whether or not the court should be granting their own orders or not. And when acting under an EPOA, the attorney must involve the donor in decisions as far as possible and act consistently with their wishes and in their best interests. So they can't turn a meat eater vegetarian. That's often an example that I would give, just because the attorney thinks that the vegetarian diet is more ethical. It would need to be in the best interest of the donor. And essentially, a bit like wills, the donor doesn't need to understand all the details, particularly if their life is relatively simple and straightforward. They just need to know that they are placing significant control, and it's really big. Like the fact that someone can put you in a home and sell your house that you might have spent 60 or 70 years of your life in, and sort of making your own, is very significant. But that you'll putting your life into a safe pair of hands, and that you know who that person is and you trust them. And just that note that only a qualified health practitioner can certify that a donor lacks capacity. So that needs to be in writing. It can't just be, mum's lost her marbles, I can now act. You would need to take mum to usually her family doctor, but it could be someone like a psychogeriatrician, etc., to make that assessment. And just as a quick note, the courts do have some quite wide powers, essentially, to look into EPAs or EPOAs as to whether or not they are valid, whether or not the person had a capacity to make them, and whether or not the attorney is truly acting in accordance with the EPA and in the best interests of the donor. And that's not just, so the donor could apply. So for example, if you had a stroke, you lost capacity, but then you recovered, and then you had concerns about how someone had acted as attorney in the interim, you could apply yourself to review those decisions. But the attorney, if, for example, family members are saying you aren't doing this properly, can also go to court and say, justify that I'm okay. But also family members and other listed professionals like social workers can also take steps. And that, for example, gives powers to things like age concern to step in if they think there's a situation of elder abuse. And the courts can suspend, revoke, or terminate an EPOA. And then there's just a note that, if there are no valid EPOAs in place, then those court orders that we talked about may be required. The difference between personal orders, welfare guardian, is the nature of the extent of the powers. A personal order might just be you have to take some medication a certain number of times per day, but otherwise you can live your life as you want. And property administrator versus manager is just if you've got only a small amount of property. It just needs to be administrated, and there are less obligations upon the person. Okay, it's ran a little long, but hopefully not too long. Does anyone have any questions on this topic or comments? Okay, then, so I will stop the recording.